Welcome to Gosfield and Shay on Health Law.
Welcome to another episode of Gosfield and Shay on Health Law. Dan is a healthcare attorney focused on regulatory compliance for physicians, including Medicare, enrollment and billing, HIPAA, fraud and abuse, and emerging legal issues in electronic health records and artificial intelligence. He's known for making complex rules practical and accessible for medical practices. I'm Evan Mack, and today's episode we're talking about Medicare enrollment and why it's a lot more like home ownership than most people expect. It's not something you set up once and forget. It requires ongoing maintenance, attention to detail, and staying ahead of changes. Hello, sir. How are you? Welcome.
Hi, Evan. Thanks for having me today.
Pleasure. It's a pleasure, Dan. But Medicare enrollment is often treated as something that gets, completed once and then put aside. Where does that framing start to break down?
Almost immediately. Medicare enrollment actually requires constant updating of changes to the information that's in the applications themselves. Whenever that kind of information changes, you have to update the form, and we'll talk more in detail about that later, I'm sure. But it requires constant maintenance, as you said at the outset.
So once a provider is enrolled, what ongoing obligations come with maintaining that enrollment?
So, as I mentioned, you're supposed to update the information whenever it changes, and that can happen at any time. But in addition to that, there are also requirements to respond to revalidation requests. That's supposed to happen every 5 years, but it can happen in what's called off-cycle revalidations. And those can happen, every 2 years in some instances. A revalidation is where you're submitting an entirely new application top to bottom instead of just updating the one piece of information that's changed. It's basically submitting a whole new application from the ground up.
So then what types of changes trigger a requirement to update Medicare enrollment information, and how tight are those timelines tied to those updates?
So any change in the application information, any of the information that's captured in the application form, when that changes, it has to be updated. In most cases, that information has to be updated within 90 days of the change occurring. But for a few types of changes, it has to be reported within 30 days. Those types of changes are changes in ownership, changes in any practice location. So if you're adding a location, getting rid of a location, changing an address, something like that. And reporting any adverse legal actions. That has a much tighter time frame for reporting. For 30 days, you have to report that change.
So where do practices most often fall out of compliance with those requirements, even when they have systems put in place?
What I tend to see is really sort of two general ways that practices will drop the ball on this. One of them is where there's a change that was supposed to have been reported, a one-off change, and someone either didn't realize that that information had to be reported at all, or they just blew the deadline because, things happen, you drop the ball, something like that. The other bigger one, which is far more of a problem, is when you fail to respond as a practice to a revalidation request. And that can happen for a number of different reasons, but any time that you fail to respond to a revalidation request, that can get pretty risky for the practice.
How does Medicare treat, deactivation differently from revocation of billing privileges? And what does that difference mean in real terms for a practice?
So this is a really good question. Deactivation is, well, really what it sounds like. Your billing privileges are deactivated. It's like they flip a switch and they turn them off. But the good news is if you correct whatever they say is wrong, they can flip the switch and turn them back on. Now that can still impact your cash flow, but at least it is an easy thing to fix. Revocations are much more serious, and revocations tend to be used in instances where there is some kind of major noncompliance, or where CMS, or the Medicare Administrative Contractors, which are sometimes referred to as MACs, if they if based on the regulations, you fall within a category that's viewed as sort of threatening the integrity of the Medicare trust fund. So felony convictions can lead to revocations. Misuse of billing privileges or abuse of billing privileges can lead to revocations. And the impact of a revocation is that you are kicked out of the system and not allowed to re-enroll for at least a year and up to 10 years. And in some instances, CMS can determine that you're not engaging in compliance and you're actually trying to find workarounds, and they can extend the revocation by another 3 years, even if that goes above the 10-year maximum. So you are out for that whole time. You lose all the billings for that time. It is very serious, and you're not allowed to re-enroll until you've sort of paid your dues and been out of the system for however long they're keeping you out. And that 1 to 10 year window can vary based on the severity of the problem in CMS or the max determination.
Wow. So Daniel, what tends to happen from a billing and cash flow standpoint when a practice's enrollment status is disputed or disrupted?
So when a practice's billing privileges are deactivated, or when there's a revocation, in either case, the bottom line is you can't submit claims to Medicare. You won't get paid by Medicare. That can create major cash flow problems. And depending on how much a practice relies on Medicare revenues to stay afloat, it can potentially imperil a practice's ability to operate at all. Again, obviously, this is much more serious in the case of a revocation, but even a deactivation that stretches on for a while can cause major problems for a practice. So it's important to stay on top of all of this stuff as a kind of preventive medicine, if you will.
Revalidation is something that often gets overlooked. How does that process actually come up, and where do practices run into trouble with it?
As I mentioned, revalidation is supposed to happen every 5 years. It can happen more often than that. The way that it occurs is the MAC will reach out to a practice based on the contact information, address, etc., that the MAC has on file, and then the practice has to fill out a revalidation, a whole new application form to bring all of their information up to date. That keeps the information in Medicare's databases fresh. It can sometimes capture information that wasn't properly updated, and it gets updated in that process. Um, where it can become a problem, and this is unfortunately more common than you might think, is where a practice has failed to update its contact information. And so the MAC sends the revalidation request to an address that the practice is no longer using, or to an email address or other contact info that isn't actually going to anyone who's checking it anymore. Then the practice ignores the revalidation request, and that leads to deactivation or in some cases revocation as well.
You've written about, situations where outdated or incomplete information creates problems later on. Can you walk us through an example of how that plays out?
Sure. So we represented a practice, this was years ago. They had a physician who had worked with them for a number of years, but had then left the practice something like 10 years prior. The physician moved across the country, was practicing on his own. Our client was doing their own thing. Nobody had had anything to do with each other for 10 years. And all of a sudden, my client gets a notification that they have failed to report an adverse legal action. And so CMS was threatening them with a revocation. So pretty serious stuff. But it turned out that what had happened was the physician who had left the practice had never been removed from the practice's record. And when he had his license revoked in another state, it looked like the practice, our client, had failed to report that revocation or the revocation of his license. And so that triggered CMS saying, hey, you failed to report, so now we're going to revoke your billing privileges. We wound up getting in touch with CMS and saying, hold on. This guy hasn't worked there for a decade at least. We have pay stubs that prove this. We will file an affidavit that swears up and down this guy hasn't worked here for years. And as a result of that, CMS said, okay, that's fine. Forget the revocation. We're not going to do anything. Just make sure that the information gets updated. There were some other aspects about what reporting obligations existed at the time that he had left the practice and whether they had to report it within a particular time frame. But in any case, we wound up getting that practice off the hook. The problem with that is a lot harder to do nowadays. It used to be that you could call a representative at the MAC on the phone, because they would include their contact info when they sent these letters saying, oh, we're going to take away your billing privileges. But now they don't do that. So it's a lot harder to get in touch with them and to sort of engage in that kind of informal negotiation to resolve the issue. It is far better, therefore, for a practice to stay on top of its details and make sure it's reporting changes as it goes, rather than rely on, well, it's okay, we'll clean it on the back end. Don't do that. Don't rely on that. There's too much at stake.
So from an operational standpoint, how should a practice be managing enrollment on an ongoing basis to avoid all these issues that you were talking about?
So I can think of a couple of steps that practices can take. The first is having whoever is responsible for updating the information be someone who understands the regulatory requirements, knows what the details are about what's in the applications, what has to be reported, and when it has to be reported. What time frames do you have to respond? On top of that, they need to, on an ongoing basis, when information changes, update that information. But in addition to that, I think it is generally a good idea for a practice, let's say once a year, to go through their information, check through it, make sure that it's all up to date so that you can avoid a problem like, oh, wait a minute, this doctor hasn't worked for us in years. Or, oh my God, I can't believe we forgot to remove this contact information. Sure hope we didn't get a revalidation request sent there. And you can update the information on an ongoing basis. Kind of like how in your house, you change the batteries in your smoke detector every year. You change the batteries in the flashlight. Same kind of concept. You're just engaging in a little ongoing maintenance to make sure that you're heading off major problems before they happen.
Good stuff. Daniel, thank you for your time. Thanks for the information.
My pleasure. Thanks so much for having me.
Right. Thanks for listening to today's episode of Gosfield and Shay on health law. If your practice hasn't reviewed its Medicare enrollment information recently, this is a good time to take a closer look at how your information is being maintained and updated. For more guidance on Medicare compliance and physician practice issues, visit gosfield.com. Be sure to like, subscribe, and leave a review if you found this episode helpful. Thank you so much, and we'll see you guys next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.